So we have already seen Article 358 and how it automatically suspends the freedoms under Article 19 of the Indian Constitution during the imposition of a national emergency. Now we will look at Article 359 now. During a national emergency, the fundamental rights of the citizen can be suspended. However, Article 21, that is the right to life and personal liberty, cannot be suspended. I already spoke about this when we were talking about Article 358, that Article 20 and 21 cannot be suspended even when there is a national emergency. So Article 21 is right to life and personal liberty and it cannot be suspended. Article 359 gives effect to this. Article 20 also remains in force and it is enforceable. This provision was added by the 44th Amendment Act of 1978. All the other fundamental rights may be, but not necessarily, temporarily be suspended by the state until the emergency is in action. So all the other fundamental rights, for example, Article 14 can also be suspended during the emergency. But it is not necessarily suspended, but they can be temporarily suspended by the union government till the emergency is in action. This is also given under Article 359. So under Article 359, Articles 20 and 21 cannot be suspended even when there is a national emergency. However, other fundamental rights can be temporarily suspended till the emergency is in progress. The fundamental rights that are suspended under Article 359 are listed through a presidential order. The time period of suspension, which might be for the entire duration of the emergency or for a smaller period than that, is also mentioned in the presidential order. Perhaps the most draconian measure is that no remedy lies for anything done during the emergency when the freedom remains suspended. So the state is not responsible for any action that it does during the emergency when the fundamental rights are suspended. Even such acts continue to remain valid and legal. So there is no remedy for anything done during the emergency or if any of the freedoms are transgressed during the emergency. Yet reprieve comes from the court, as only those laws and executive decisions which are related with the emergency are protected from being challenged in the court. Other laws aren't. So let's say certain fundamental rights were removed. For example, the freedom of speech and expression under Article 19 remains suspended under Article 358 when the emergency is imposed. Now let's say if your freedom of speech was curtailed, that is valid. However, let's say some of the laws were already in place. Let's say Article 20 and 21 continue to remain in place. Now let's say under 21, if your let's say your relative's life was taken away, then such a right can be challenged in the court. Only laws that have been protected during the emergency under Article 358 and some under Article 359, only those cannot be challenged. However, if some wrongdoing is committed for a law that is in place during the emergency, or if a person was killed during emergency by the state, then you can take the state to the court. So reprieve comes from the court, as only those laws and executive decisions which are related with the emergency are protected from being challenged in the court. Other laws aren't. So the state cannot wantonly do anything during an emergency. Some laws are still in progress and some laws still have effect. And if those laws are transgressed, then the individual or a group can take the state to the court. So the next question that we have to look at is, can the term of the parliament be increased during an emergency? So the term of the Lok Sabha can be increased 1 year at a time, any number of times, by a law of the parliament. So the term of the Lok Sabha can be increased 1 year at a time, any number of times, by a law of the parliament. So the parliament itself is increasing the term of the Lok Sabha by 1 year. The Rajya Sabha is the permanent house which is never dissolved. So it goes on and on. So the Rajya Sabha is the permanent house, never dissolved, so it goes on and on. Similarly, the life of the state legislative assemblies can be extended 1 year at a time, any number of times, by a law of the parliament. So please note this, even to extend the life of the parliament has to pass a law. Even to extend the life of the state legislative assemblies, the parliament has to pass a law. And in both cases, you can only extend it by 1 year at a time. However, it can be increased by 1 year any number of times. However, the extension only lasts up to a maximum of 6 months after the emergency is revoked in both cases, that is the Lok Sabha and the state legislative assemblies. Now let's say on the 1st of January, the Lok Sabha's tenure has been extended by 1 year during the national emergency. However, on March 31st, the emergency has now been repealed. That means the Lok Sabha's term that has been extended by 1 year will be cut short, and it can exist only for 6 months after the repealing of the emergency. That is, if the emergency was repealed on 31st March, then only 6 months from then the new Lok Sabha will be valid, and before that the general elections have to be held and the Lok Sabha needs to have new members. So the extension of the Lok Sabha only lasts up to a maximum of 6 months once the emergency is revoked in both the cases, that is that of the Lok Sabha and the state legislative assemblies. So during the national emergency of 75 to 77, the tenure of the parliament was extended twice by 1 year each time. So the next question that we'll look at is the declaration of emergency subject to judicial review? The question as to whether a declaration of emergency is subject to judicial review was still open in 1975. Indira Gandhi, after her infamous proclamation of emergency in 1975, enacted a constitutional amendment act that specifically kept the emergency outside the scrutiny of the judiciary. This was done using the 38th Amendment Act of 1975. So using the 38th Amendment Act of 1975, Indira Gandhi kept the emergency outside of judicial scrutiny. However, the Morarji Desai government in 1978 enacted the 44th Amendment Act to reverse a number of draconian and evil amendments brought into force during the emergency. The provision of the 38th Amendment Act that kept the emergency outside of judicial scrutiny was deleted. So the 38th Amendment Act that kept the emergency outside of judicial scrutiny was deleted. This was done using the 44th Amendment Act of 1978. A proclamation of emergency after this was subject to judicial review. In the Minerva Mills case of 1980, the Supreme Court further held that the proclamation of emergency can be challenged in the court on grounds of malified intentions, or that the emergency was based on wholly extraneous and irrelevant facts, or is absurd or perverse. So in the Minerva Mills case of 1980, the Supreme Court said that the emergency can be challenged in the court on grounds of malified intentions or on wholly extraneous and irrelevant facts, or that emergency is absurd or perverse. So on all of these grounds, the emergency can be challenged in a court of law. This is what the Supreme Court said in the Minerva Mills case of 1980. We will next look at the effect of the emergency or a national emergency on the powers of legislation. Thank you.